I'm a clinical and director of the Health Justice Clinic at Duke Law School. And I'm very excited to welcome you to our Teaching Justice webinar series and our final session for the 2023-2024 school year. We're so thrilled to have with us today Julia Hernandez from CUNY Law, who will be leading us in teaching early family defense.
Hello, everybody. I'm Layla Halas. I'm a clinical professor of law at Tulane Law School, and like Allison, a member of CLIA's Best Practices in Pedagogy Committee, which this series is a part of. Today's talk is part of this larger series that we've been working on now for several years, and has been kind of really fruitful in terms of all the kind of conversations we're able to have, where we're thinking about how social movements intersect with clinical pedagogy and kind of new approaches to teaching justice in the classroom. So this is going to be the last of this series, but we do plan to have another series in the coming academic year. So we encourage you to kind of stay tuned to the CLIA website and clinic and lecture listservs for more updates and information about the web series and where to find all of the recordings.
And for this session, as always, we do encourage you to use the chat function. If you have any questions or comments or feedback during the presentation, please feel free to throw it up on the chat. Layla and I will be monitoring. And Julia will also be making some time and space, I know, for some Q&A. If you're comfortable leaving your video screens on, we welcome you to do so. We just ask that everybody please mute themselves during the pendency of the presentation. With that, I'm going to hand it over to Julia, but thank you all so much for attending, and we look forward to the presentation.
Thanks, Allison, and thank you so much, Layla, to both of you for organizing this really amazing series. I'm really happy to be a part of it. My colleague and co-conspirator, Tarek Ismail, is not able to join us today, given the Eid holiday, but I'm hoping I'll do both of us justice in the presentation. It's great to see you all here. I see some familiar faces, so that's really nice. So I'm going to talk a bit about teaching radical early defense in the context of family policing. And so here's the overview. So a brief introduction to CUNY's Family Defense Practicum, a bit of the history and an overview of what we do there. Then I'll do sort of a really quick and dirty primer on CPS investigations for those folks who aren't familiar with it. And I'll also situate that in the context of our practice here in New York City and in New York State. Then I'll talk about radical early defense and investigations, which is sort of the heart of our practice, and then we'll wrap up. Okay, so CUNY's Family Defense Practicum began as a formal course in 2020, which is notable because we offered it for the first time as a credit-bearing course during the pandemic in the spring semester of 2020. So we started out in person and then quickly shifted to an online format. And prior to that, we had been sort of working with students informally as they expressed interest in engaging with parents and with movements in the family policing system. So that primarily looked like students being interested in working on helping parents to amend their administrative record in terms of being listed on the state register for child abuse and maltreatment. So we offered it as a formal course in 2020, and since then it's been offered in a couple different iterations. But the one that we're offering now, I'll talk about because I think it's quite interesting. We offer the course this semester. We're running it for 2L students, and we're offering it for 7 credits. So we offer it right now 3 credits seminar and 4 credits as a practicum. So the 3-credit seminar is open to any student at the law school, so has more of a broader enrollment. And the 4-credit practicum is open to a smaller subset of students, only 2L students, And that satisfies their requirement to take what at CUNY we call a Lawyering Seminar 3, which is a bridge between the first-year lawyering seminars and the clinical experiences that students are required to engage in the third year. So the subset of students who are in the practicum, like I said, is smaller, but they're also co-enrolled in the seminar. So we get a lot of time with those, with that smaller group of students, which is really nice. It's the first time we've offered it this way, in the sense that we've been able to kind of break out the seminar portion from the practicum. And that's given us a lot of freedom in our teaching. So the seminar portion is a thematic exploration of the topics that relate to family defense. We're happy to share that syllabus. It's like I said, we offered this course for the first time this year, and so it's a bit. It is more fixed though than the practicum component. Sorry, my 6-year-old is here, so and is asking for my attention. So just give me 1 second. So in the seminar, we are exploring each week a new topic, and some of those are race and racial capitalism, investigations, mandated reporting, reproductive justice, political economy and public welfare, disability, children's rights, settler colonialism, and family separation. And so we take each of those in turn. We assign obviously some readings and a guided memo for those readings. We ask students to sign up for a week to lead the class discussion on a particular theme. And then some weeks we have guest speakers that are related that are doing work in the fields that we're studying that week. For the readings, we've experimented this semester with like a lot of sort of broad readings, like, books, chapters from books, full books, law review articles, investigative reporting, op-eds. We've assigned some podcasts. So trying to make it sort of mixed and varied for the students. And the student-led discussions have also been a really nice part of that, which isn't really something that we were able to do in the seminar, aside from sort of rounds and supervision. So the practicum is we've really had so much time to focus in the practicum on skills. So really, teaching the substantive law, lawyering skills, and then obviously supervision and rounds. And so that's how we've broken out the different parts of the course this year. In our docket, initially, like I mentioned, we started off doing administrative appeals, and then we've shifted almost exclusively to early defense, with the exception of some federal civil rights litigation relating to the family police system. So I just want to say a tiny bit about how and why we made that shift. So in New York State, when folks are placed on the administrative register for child maltreatment, there is an appeal that's available to them, but like in most places, I'm assuming there's not a right to counsel, so most folks are unrepresented. So we started filling in that gap a bit and representing people in those administrative hearings. And just like our practice in the judicial sphere, it sort of drove home for us again, like how much happens at the front end of a family's interactions with CPS. From that first call that goes into the hotline, through the investigation, up until the time that someone is in court proceedings. There's so much that happens up until that point that families don't know their rights, and is then used against them later on in potentially a court proceeding, but then also later on in the process to get their name taken out of the register. So we started to think about that space, and we've written a little bit about it, about our practice in that area and our early efforts in this area. So that's where we began to, I would say maybe about 1.5 years ago, really focus the majority of our efforts. One other thing I'll say about the practicum really quick, though, is that I forgot to say is there's some overlap between the seminar and the practicum. So we started about mid-semester this year offering the opportunity for students in the seminar who are not in the practicum to do some of the Know Your Rights presentations and take on some of the early defense cases. That is giving us the ability to have more capacity to do Know Your Rights presentations and to take on more early defense cases as we become, sort of known in the community as doing it, more referrals coming in and needing just some more capacity, and also wanting to help offer these experiences to students. Okay, 1 second, sorry.
While we have like a second break, I was also thinking, since it's a nice size group, maybe everyone could put their like names and if they're teaching, what they're teaching. So we could just also just get a sense of who's in the room.
Okay. Move to the next slide. Okay, so I'm just going to really do a super quick run through of investigations, which is where we focus our work. So it starts with a call to a centralized hotline, a child abuse and maltreatment hotline, which exists in every single state. The report is then sent down to a local agency to investigate, and that agent will seek contact with the family in a variety of different ways, either by showing up at the home or by sometimes making a phone call first if the case is not marked as urgent. And in New York, there's 60 days to complete that investigation. And during that 60-day period, a really, really broad range of things can happen. And so that's where we're really interested in standing alongside families as they try to navigate this. So that's where we're going to focus. I'll focus the rest of the talk in terms of our clinical practice. And then at the end of that 60-day investigation, there's an administrative determination, which I mentioned earlier. And that's made by the caseworker, probably in conjunction with their supervisor, who determines whether the investigation has turned up enough evidence to either indicate the case, placing the person's name on the statewide central register, which has employment consequences, consequences in the ability to foster a family member or another child, and licensing consequences, or whether the case is unfounded, in which case the adult's name will not go on the register. So I want to talk about, in terms of this broad range of actions, we've focused sort of on the searches aspect of an investigation. So in New York City, there are about 56,000 investigations annually, and that means that every day about 150 children are being investigated. So ACS is seeking, in New York City, we call the agency ACS, is seeking to interview 150 children. Most of the investigation is done on the consent of parents. And a lot of times the parents aren't aware of their rights, that they're giving that consent, and they're not aware of their rights to refuse that consent or to negotiate that consent. And so the home searches generally take the form of an entry into the home, inspecting the entire home, gathering evidence, oftentimes beyond the scope of the call that led the investigator to the family's home, recording the conditions of the home, whether there's food in the home, what medications that family members are taking, the sleeping arrangements of the family, taking pictures, interviewing the parents and other adults in the home, interviewing children, oftentimes outside of the presence of their families or of their parents, asking them to view parts of their bodies that are normally clothed. And so this is the context in which we are hoping to work with families. So just some sort of stats on CPS home searches nationally. These are on the left, 2020, 2019 figures and 2020 figures, which account for the pandemic. So there's about, let's just say, 2 million home searches per year under the guise of child maltreatment or child abuse. But only 16.7% of investigations actually turn up some, and the standard is different in different states, but some evidence of child maltreatment. And the vast majority of those is neglect, not abuse. I think the figure is something like 90% of those are related to neglect and not abuse. So when we think about home searches, there's what we teach our students is to see these home searches, as subject to Fourth Amendment constraints, or they should be subject to Fourth Amendment constraints. But that these searches, the government has incredible amounts of power, and it has more power than the criminal police in many instances. Sometimes folks who work in the criminal legal system or police themselves are sort of shocked at how ACS and Child Protective Services kind of has a blank check to search a family's home and to gather evidence. And there are very few limitations on that, or even consequences for failing to follow particular procedure. So there's not actually an exclusionary rule in family court that families can sort of use later on. So in terms of this is where we work. So when we think about why help families during the investigation phase, these are just some of the harms of investigations. And I know many of you on this call have worked with families during investigations and during court cases later on. So we could add to this list sort of on and on. But the fear of someone's children being taken from them is I think probably the biggest, one of the biggest fears that parents have. The sense of community distrust that these investigations sow in a community, undermining the a parent-child relationship of trust and a sense of safety that a child's parent can protect them, an invasion of the home, an invasion of privacy, the shame of an investigation, right? The sense that, like, well, if someone made a call about you, there must be something going on. And so this sort of fear of even talking about the fact like that someone is under investigation. Coercion to continued surveillance, the way that investigative agencies often coerce parents to accept and to consent to ongoing services, which really allow the government through not-for-profit organizations to continue to surveil and report on the family to the government agency. And of course, removal and potential family separation, not just temporarily, but potentially through the form of a termination of parental rights case, which would permanently sever the bond between a parent and their child. So what is so just to wrap up some of the context of this, 83% of investigations result in unsubstantiated cases. And we talk with our students about what would happen if families pushed back against a CPS home search. So the ACS can enter a family's home on consent or with a warrant, or under exigent circumstances. So this graphic here is from a news report that came out last year, and the number of warrants that are obtained in 56,400 investigations is 94. We just actually got the figure from last year, and I think it was 202. I think ACS had applied for something like maybe 198 and 202 and 198 of them were granted. So the vast majority of those applications are being granted, but the vast majority of the cases don't have a search warrant issued in them. So it's less than 0.2%. So there's a burgeoning movement in New York to provide families with so-called Miranda rights during an investigation. And this is something that our students have worked on and taken the lead from folks who are impacted by the family policing system to help support this legislation. So I've sort of pasted some of the text of it on the left side, and on the right side, just to kind of drive home maybe some of these, the points about rights during an investigation. This is text from the ProPublica report, and I'll just read a couple of the gems here. So rights, no, we never did that. I didn't even know that was a thing, says one caseworker. And to up the pressure, some caseworkers said they would use lines like, and to up the pressure, meaning to get into the home. I don't want to discuss your business out here in the hallway. Well, I'm not going to stop coming. Why not if you don't have anything to hide? And oftentimes they would say, like, we'll put a warrant on you, which those caseworkers have admitted is misleading. This is stuff that we've seen every day in our practice, not just representing people in investigations, but representing people later on who still want to talk about the way that they were sort of steamrolled during an investigation. Okay, so just to wrap this up, there's over 1 million investigations each year. Most of them don't actually turn up any evidence of abuse or neglect, and a very, very small minority of those investigations are conducted via a warrant. And the reason for that is because families are giving their consent to the search. So what is early defense, and why do we do it? We've sort of played around with the definition of early defense and now our conceptualization of it is that it's legal representation before or at the inception of an investigation, distinct from a court case, plus community education. So most of the time, folks will be assigned an attorney at the filing of a petition against them in court. And like I mentioned earlier, so much happens before then that really stacks the odds against our client's favor when the agency is going to court armed with, sometimes hours of interviews with the parent, an investigation into the home, evidence gathering in the home, and then we meet our client at arraignment and are facing sort of either a request for surveillance of the family or to remove a child from the home. So the purpose of doing early defense, as we see it, is to not just to avoid a court filing, but also to eliminate or to reduce the harm to the family that happens during an investigation, and also to build community power and knowledge around folks' rights during these interactions with what we consider to be law enforcement. We take our referrals from the community. We don't take our referrals from the Child Protective Agency. We've made a fairly deliberate decision to do this, to work against the co-optation of early defense, which we thought of that it would happen, and we've started to see that happening already with funding, with Title IV-E funding coming down through the federal government and being doled out to defenders' offices with lots of conditions on them. And not to say that representation isn't critically important, but we are really hoping to stay outside of those structures. So our clinic provides very active, full representation in the investigation. And that is distinct from, I think, what a lot of institutional providers are limited in doing in terms of providing limited representation in an investigation. Okay, so I'm going to talk a little bit about, I'm going to give an example of an early defense case that we worked on this semester to try to illustrate some of the, what we're referring to as touchstones in experimentation that we've been playing around with. Just maybe we can take a 1-minute break, 1 second. Okay, so, oh, I forgot that I put these in. These are just some slides of our students just this semester doing some Know Your Rights presentations in the community. And the top one is them performing a skit, and the bottom one is them, or the right-hand one is them presenting on investigations. Okay, so here's an example, Miss W. So Miss W is a young mother of a 4-year-old. She's had prior experience with ACS, and she was, as a mother, but also a long-standing experience with ACS as a child. So this is actually someone who does know some of her rights and is interested in asserting some of those rights. So she was facing 2 reports, one that she had left her child alone in a shelter for a brief period of time, and the second that was made by a shelter staff, and the second that she had left her child unattended while another family member was supposed to be watching her, And during that time, she walked out of the home and went to the corner store. We asserted representation, which is a whole thing that's a bit confusing in terms of how we actually do it, because ACS doesn't recognize, the caseworkers don't refuse to speak to us as attorneys, and they don't, it's not easy to get in contact with an attorney there, because attorneys aren't assigned until the case is brought to court. So we've sort of figured out a way to assert representation, but the ACS scheduled what they call a child safety conference, which generally is a conference in which they there's a couple different caseworkers, maybe the primary caseworker, the caseworker supervisor, someone they call a parent advocate, but is an employee of ACS. They refuse us to participate in those conferences. So our client chose not to attend the child safety conference, and immediately the city filed a neglect petition against our client in family court. And on the same day at arraignment, offered an ACD, an adjournment in contemplation of dismissal, and a really short one at that. I think it was a 3-month ACD. So clearly, the point of filing the petition was just to obtain the court-ordered supervision over the family and to coerce her to submit to their supervision for a period of 3 months in order to get the case out of court. So in like traditional clinical fashion, you know, and this happened incredibly quickly. What did we learn from this case is sort of what we what I want to focus on in terms of how we're thinking about experimenting in this area. So because ACS won't allow attorneys into this really critical conference where so much is decided, where it's decided whether a child stays home, whether a child is being removed, whether a child goes to a family member, whether services are going to be requested or the family will be coerced into services. Defenders' offices have employed social workers as a workaround to this particular requirement. That's oftentimes an incredibly critical intervention when a social worker can attend this conference. We don't have social workers, and so we go back and forth on like, oh, we really need a social worker, but also we don't want to participate on the agency's terms. And we think that it's proper for a parent when they're being investigated and interrogated on really consequential issues, like sometimes, you know, did you hit your child, which can have criminal and civil liability, that they should be afforded the benefit of having an attorney beside them in that conference. So we've taken the position that we are not going to find social workers to work with us on this particular issue. We do think social workers are important for our practice in other ways, because it doesn't fundamentally change or challenge the terms of engagement or shift the power balance between the agency and the family and the community writ large. So I'm going to return to this kind of dilemma, because that's our current dilemma. I'm just being really honest. That's where we're kind of we're a little bit stuck right now. So setting the stage with that, right, that we're stuck on this sort of issue of what do we do when our clients are supposed to go sit in a meeting like this alone and we are being refused entry. We can prepare them. There's lots of things we can do, but how do we work with our students in this context? So here's just a couple sort of, and we're zooming out a little bit too. These are the things that we've, as time has gone on, sort of kept in mind as like touchstones in our experimentation. So we're constantly trying to reframe the way we understand the system in terms of power and in terms of systems, right? Who holds the power in this particular interaction, and how can we shift that? What are the systems that are involved right now? So we work with administrative bodies. We work with members of the executive body, which is the administrative agency, the city, ACS. And then oftentimes we're interfacing with a judicial body as well. So many of our clients are also involved in the criminal legal system, sometimes from the same allegations or different ones. Many of them are in shelter. Many of them are undocumented. So how are we understanding and mapping all of the systems that our clients are engaging with and that are bearing down on our clients? And how do we understand the power involved? And how do we think about shifting that? We also try to situate ourselves, both as practitioners and as lawyers and as students, and the work that we're doing in the long-term struggle. That there is no specific one thing that we can do to change this system, in the next several months. So we are all working towards something that is a long-term struggle that we have to be sort of prepared for and willing to engage in over the long term. And we also like to remind our students that this project at CUNY is a student-initiated project. And to situate themselves in the line of CUNY students that have began this project and carry it forward over the semesters. So it's oftentimes sort of nice to refer to students' predecessors in the clinic to sort of show them the work they did. And we also have the last 2 years been able to work with teaching assistants who had been in the clinic the year before, which is one benefit of having 2 Ls, so that when they're 3 Ls, they can be teaching assistants. We talk a lot about struggles over narrative. And this is something that actually comes up more than we had realized. But last year, when the ProPublica article came out, ACS responded and said, we have a responsibility to conduct what we call home evaluations. We don't call those home searches, and we don't call them home investigations. So we said to ourselves, like, that's really funny. That's such a, it's not a home evaluation. Like, parents don't experience it as an evaluation. They experience it as a search of their home and as an investigation of their home and of their family. So that's just one struggle in terms of the narrative. Another is that in this space, there's a sense that the state thinks of the family, thinks of the parents as opposed to the children, thinks of them as sort of the enemies of the children, as folks who are hurting their children or potentially hurting their children. And so when a case will get to court, everyone is kind of separated. The family is separated, at least sort of legally speaking, in terms of representation, because everyone gets their own attorneys, the child, the parent, and each parent will have a different attorney. So at the investigative stage, to push back against that narrative, we assert representation for the entire family. And oftentimes, we've just started to get some pushback. I think we've just started to get some pushback on that in terms of the agency saying, well, who do you represent? And we say, we represent this family. And we actually had a caseworker tell our client once that she represented the child. She said, I'm a representative, I represent your child in this investigation. And so the sort of confusion that caseworkers have, misleading language, puts parents in a situation where they're just confused about what their rights are, about who's stepping in to assert, some kind of, I'm here to help your child. I represent your child. Parents are like, I never asked this person to represent my child. How are they representing my child? So we've taken the position that the family is a family unit, and until proven otherwise, we represent the family. The parents are doing the best that they can by their children and not abusing or neglecting them. And until proven otherwise, that's the case. And we will represent the entire family for as long as we can, which is generally up until the time a case is filed. So those are just some examples of like struggles over narrative that we've been trying to think carefully about. Positive and negative conceptions of justice are something that I actually learned from this CLIA series myself, from another presentation. When we're thinking about what the problem is, can we not only think about like what we don't want the agency to do, but what would a positive articulation of justice in this field look like? And so that's also something that's kind of an antidote to how awful a lot of this work feels. Can our students articulate positive conceptions of justice around, around child abuse and maltreatment investigations. What is the ground beneath our feet is, I think for students in particular, is really, really important. Sometimes we feel like, and students feel like they don't really know where they're going. They don't know what they're doing. They kind of feel like, we're on our own doing this, either themselves as students or us as kind of the legal team, because it is something that there's not a lot of guidance on. So we talk a lot about, like, we are not doing this alone. This is not something that we aren't supported in. And the ground beneath our feet is always our clients, and extending out from our clients, their communities, their families, and their milieu. And if we can sort of draw on that, and if we can leverage that, that's the ground beneath our feet. And the ground beneath the agency's feet is completely different, but really sort of contrasting that, the basis for our representation, the basis for the work that we do is, I think is something that sort of helps to ground the students in, like, okay, like we have authority too, right? Like our authority comes from our clients and their power. So reminding ourselves what that is. Reflection obviously is key. We are constantly thinking, okay, like what did we learn from that interaction? What did we learn about what happened just now in that case or in that event in the case? So constantly kind of making notes about, like, okay, like that didn't work, or this thing did work, or, oh, we learned something new about the agency. A lot of what we do is learning about the ins and outs of this behemoth agency. Like, what are their internal policies and practices? How do they work? What makes them tick? Who are the players? And, they're oftentimes changing. What is the structure? What do they believe their authority to be? And why are they doing particular things? We also are learning about, okay, we tried this approach with this client and, it didn't quite work, or, oh, that worked really well. So constantly thinking about, like, what should we do differently next time, building on every single early defense case that we have, and really trying to kind of mine it afterwards for knowledge and for information and for ideas. We are always trying to anticipate the state's responses. Sometimes we are good at that, sometimes we're not, but we're also trying to anticipate the state's responses in the long term. So we're thinking about, like, if folks resist more, like we're suggesting in some cases might be the right move, is the city just going to respond with getting more warrants? Are they going to hire more lawyers and form a warrant squad? Are those warrant applications just going to be rubber stamped by judges, or are judges really going to understand what's required in a warrant? Are they going to issue it with particularity? Are they going to limit the terms of the search warrant? In our experience so far, those applications for warrants to either produce a child or to enter a home are not particularized, and they're not specific like is required under the Fourth Amendment. We are also very conscientious of the fact that the state may just mobilize the criminal legal police more, and that will have really violent effects on the communities that are hoping to or experimenting with resisting these investigations. I mentioned before, like, the institutionalizing or co-optation of early defense, and that's something that I think we're already starting to see movement with, and thinking about, what are the dangers to that, and how can we head that off. We're also really cognizant of the fact that a lot of the Fourth Amendment protections that and some of the constitutional protections, other constitutional protections that we're advocating for, haven't really done much good in the criminal system. And so do we risk sort of replicating a system that also has not, or replicating not just a system, but replicating the advances in the system that held some promise, but then later have been sort of clawed back by case law and by practice. So those are all things that, like, we are thinking about as we've done this work, I would say, over the last couple of years, these are things that we are these are things that we're constantly thinking about and kind of adding to this list also. I wanted to say a bit about particular work with students. So maybe like the other title to the slide would be like some challenges with students. And, you know, I think students bring across the board in any kind of practice, obviously bring like different approaches to the work. They also bring different experiences, different appetites for risk, different appetites for experimentation to the table. But we find that even, and I've been kind of fascinated by this, like even in the 2L year, and we are assuming, right, like some exposure to practice, but maybe not all that much exposure to practice. There are some students who need like sort of specific guidance on unlearning regnant practices and regnant lawyering. So oftentimes our students say to us, you know, what can we do that, or can they do that? Meaning like, can a parent do that? Can a parent say, to be honest, the thing that a lot of students say to us is, well, can a parent say no? You know, we'll be on the phone with a caseworker or with a lawyer for ACS. And the lawyer will say, you know, my client needs to come in and do a home evaluation like tonight, like immediately. And, you know, when we're debriefing the call, we'll say, you know, how would you like to advise your client? You know, and they'll say, well, they have to let them in, right? And then we say, well, what if they didn't? And they'll say, well, can they do that? So there's a lot to unpack in that kind of context, in that situation. And apart from teaching the law on investigations, which we do at the beginning of the semester, we really don't give the students a ton of guidance when they are assigned an early defense case. So it is up to them to sort of figure out how to apply the law that we've taught them in the particular context that they're in. And that we find to be, that's the heart of the work in terms of pedagogy, right? Like in terms of student learning. And that's where we find the most like interesting things happen. And sometimes students get really caught up, right? So how can they sort of approach a problem when they don't have a ton of information about it? So, you know, when we, that particular example, right, of a request for a home search, right? Essentially, the government is requesting to search our client's home. And if we were to say yes, we would be giving consent. And if we were to say no, we are then saying, you know, go and get a warrant, or just back off and maybe you can see the child outside of the home. So when students say like, well, what is the permissible sort of menu of options that our client can exercise right now, we say, you know, they ask us this question, and we, of course, in typical clinical fashion, turn it back on them and say, well, what do you think? Like, what can your client do? This is the heart of counseling your client. And so, right, what's the first thing you need to do? You need to understand the legal landscape here. That's the first thing you have to do. And so varying, you know, our students vary in the sense of like whether they know how to find an entryway into this kind of problem, right? Whether they know what to do. Do they start with a statute? Do they start with the CPS manual? Do they go to the regulations? And so this is something where we're constantly navigating, Tarek and I, you know, how much do we sort of give them? Do we say, hey, go look at the CPS manual? That's a good place to start. And how much do we say, like, you know, actually, like, you should just go try to figure out that problem on your own and let us know what you come up with, and then we can guide you from there. So that's just like sort of one example, like, you know, we ask our students, like, in that instance, well, what is required by law during a full investigation? That we have to understand for ourselves. And the answer to that is in the regulations. It's listed a bunch of other places too. But trying to see, like, can a student take a live problem, and that you're all clinicians here, I know you all sort of engage with this in many different ways, but can students take a live problem and then parlay that problem into an understanding of the legal landscape, and then considerations of the particular client's needs, goals, the milieu that the client is situated in, and how are they then going to counsel the client? And the difficulty, I think, for us is that all of this happens in an incredibly compressed timeline. So I would say that that's probably the number one problem that we have, is that the fast-paced nature of our work, it doesn't really fit in with the traditional clinical pace of work. So we are oftentimes, asking students to meet with clients at the drop of a hat. After sort of normal working hours on the weekends, we're asking them to respond to sort of message back and forth with us at various times. And we're navigating that with students, and they're navigating that themselves, and what kind of practice they want to have. It's an incredibly unpredictable area of law. One moment we could have an assurance from the agency that a child is staying home, and minutes, hours, a day later, we could face an emergency removal with no notice, or a notice that an emergency removal is going to be conducted or a court order be sought. So those are really, really challenging for us, I think, as clinicians, and for the students as well. Another thing is that these are new skills and new areas of law for all of us. So oftentimes, students will ask us a question and we actually don't know the answer to that question either. And so we're modeling with students the challenges of gaining new information, and of learning new things, and of trying new things. And we're also modeling failing, which is just, I think, trying to normalize things not working the way you want them to work, or oh, I bet on this and it didn't work out. We had our first filing against a client happen this semester, the Miss W case, and we were all pretty bummed out about that. And we're not going to try to make a loss a win in this context, but in some ways it taught us a lot, right? That our next frontier is how do we work with these CSCs? So kind of bring us back to that. The government is putting a really big roadblock in front of us, and what are we going to do to try to work around that, or work with it in service of helping our clients to resist this system? So one thing that we have not done, that we've decided that we're going to do and try, is, in terms of teaching, is we are going to try to do some early defense simulations at the very beginning of the semester. You might be surprised that we haven't done that yet. We kind of are too. So we're going to try that next semester, we do simulations in other contexts, but we actually haven't done them yet in early defense. The kinds of cases the investigations are so varied that initially we had thought, well, it's so hard to kind of come up with one that might be more standard. But I think our thinking on that has actually changed, in the sense that in every investigation, students are going to need to understand the basic frameworks of the law that we've internalized as attorneys so far. But that is not, the students don't sort of have that in a framework that's workable for them yet. So yeah, this is kind of where we stand in terms of what we're thinking about doing next, how we're experimenting in this area. And yeah, I'm happy, I'd love to hear from all of you about what questions you have about ways that you do this in your own practice. And thanks for listening to all of this.
Thanks so much, Julia. We have just a few minutes left, but if anyone has a burning question they want to pose or comment they want to put out there, we certainly welcome you to unmute yourselves or throw it in the chat, whatever you prefer.
Can I jump in with a quick question? Hi, thank you, Julia, for the presentation. It's so interesting. One question I have, unlike the current clinical work that I'm doing, and you mentioned this, the timelines are different, and particularly, I would imagine there's a lot of stuff coming up outside of the students' particular clinic hours for that week. Can you talk more about how you've kind of navigated around that, given the kind of fast-paced speed that the agencies are going on?
Yeah, I mean, we tried to the best of our ability at the very, very beginning, even before the semester starts, to send out an email about the early defense practice and to just kind of let folks know that this is what it looks like, and it will require some engagement outside of class time. So it really varies. Like sometimes there's students, and students have various responsibilities themselves. We have, for the most part, offered this. Actually, I offered it for some evening students last semester, and that was more difficult because those students don't have that flexibility during the day. Most of them didn't have the flexibility during the day. But really, I think, to be honest, I think that this question like draws in a lot of like professional responsibility and ethical questions. Like, we talk with our students, like, is it ethical to like not answer a client's phone call after hours when they're having an emergency, such that their children might be removed from them? How do you sort of suss that out, whether it's a true emergency or not? And is it your responsibility to pick up the phone after hours? I have my own personal thoughts on this. And I'll tell them that. I say, yes, that is my approach to this is like, absolutely, you do. But we've had some pushback on that, some, just not a ton, but a bit. And so I think we have to work with like students' constraints or just things that they're not able to do. And so if we don't hear from a student, we'll of course pick up the slack, or we'll just do it ourselves. And then we'll debrief later. We'll let students know like what we did. It really varies, but I think that like there's a lot of talk of like boundaries in law practice, and that's not my way of approaching this. Like, I think that we all have enough. I don't know, I can go on and on about this, but I think that like in a practice area like this, we teach the students that it's our responsibility to be there with a client, like no matter what time it is, and there's, I'm really lucky to have a partner in this work who is so dedicated and amazing, and a group of students most of the time that is like, it's never really a problem. But I also get it, like students wanting to talk about that question, and it's a conversation.
So I think we're almost at time. So I just want to really thank Julia again, and Tarek, although he couldn't join us today, for this wonderful presentation. So many of us I know who have experience in the family regulation system and family policing system know just how shrouded in secrecy this system can be, and to be able to bring visibility to this practice and normalize it across the clinical community is so important and so powerful. So thank you so much for sharing your presentation with us today. This will be recorded, or has been recorded, and will be up on the CLIO website probably within a week or two. And as Layla said before, we will be posting our lineup for next year probably in the fall. So please stay tuned, and have a wonderful summer, everyone. And thanks again to Julia.
Thanks, everyone. Thanks, Layla. Thank you, Allison.